It's a very big decision to make. You may not get to see justice administered. And I don't know how that gives confidence in the process to fight for the freedom of this type of information.
How vocal the judge was today. He talked the entire time, and he does not seem to really be a fan of cameras at all, and he doesn't seem to be a fan of the media in this case in particular, feeling like they've sort of slanted things, like the cameras aren't a good idea. He talked about other high-profile cases. He talked about the O.J. Simpson case, said that he felt like the cameras made that a circus.
Boy, are they all missing the main point here that certainly resonates with the families. Of course, they're going to want access because they're the most tied to the victimization here, but they're all doing the job for justice, and that's for the community as much as it is for their own sense of their personal integrity in this purpose. How do the families feel about it?
Frustrated, feels like the whole process has been secretive from the beginning, wants transparency, doesn't understand why the prosecution is now fighting against cameras.
The community needs to determine who this individual is. You cannot ask for the community to do the death penalty without their vision, without their support, without their understanding of all the aspects of the case. It's more than just the jury members. It's the community. It's a message for everybody to understand. In Idaho, this is how we work. To me, the courtroom is truth in action. Truth in action. So why do we hide?
Viewer discretion contains true crime content that may be disturbing, intended for educational purposes, not suitable for all audiences.
Moscow and people around the country sit and wait for answers about how and why police zeroed in on Kohberger. Investigators found other DNA at the murder scene they haven't gotten the chance to review, but prosecuting attorney Bill Thompson says they've given the defense all the evidence they have, aside from one lab report they're still waiting on.
About Kohberger's defense attorneys from the very beginning. I'm not sure why Pennsylvania in this instance did not seek a resolution from the asylum state prior to Kohberger's extradition, especially since it was obvious to Pennsylvania that Idaho was asking for this extradition without a whole lot to go on.
The judge will unseal the probable cause affidavit, possibly explaining the motive and what led police to Kohberger. A document with information Mancuso says not even Kohberger knows.
I definitely believe that one of the main reasons the defendant chose to waive extradition and hurry his return back to Idaho was the need to know what was in those documents.
After Kohberger's initial court appearance in Latah County, he has the right to a preliminary hearing, which he could waive and go to a trial. But we know, Brian, based on previous comments from Kohberger's public defender who represented him in the extradition process, that Kohberger will likely plead not guilty and believes that he will be exonerated.
Once the person is already extradited from their asylum state to the demanding state, they don't have a basis to challenge the legality of the extradition. And it's a real wonder that they called him a fugitive from justice in the first place. And I've not looked up Pennsylvania's criminal code for this yet, but procedurally, he hasn't even been interviewed by police yet. So to become a fugitive from justice before he could even presume he were a suspect.
They are discoverable, and we're asking the court to order that they be supplied to us.
So, Ms. Taylor's correct. She has everything that the state has in our possession. And we have worked diligently and consistently in getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio-video information.
Now the defense and the prosecution have filed paperwork agreeing to close the hearing to the public. But there's one problem with that.
I think that the idea that the defense and the state can get together and close a hearing just by their own agreement is just simply not the case. There are other stakeholders, there are other people with interest, including the families who is, from my reading, there's a desire that the cameras be in the courtroom by at least some families of the victims. The other stakeholder, obviously, is the public, and the public is represented by the media.
Griner has argued on behalf of media outlets in courts for years. In fact, he was part of a coalition that included Law and Crime during a high-profile trial in Ohio last year. To close a courtroom, the Reporters Committee for Freedom of the Press says the judge must hold a hearing on the need for secrecy and allow the media and others to argue against closure. It's a rule from the U.S. Supreme Court. Closing courtrooms is rare in criminal cases.
It is a huge outlier. The idea of closing the courtroom entirely, that the public can't come in for any purpose, is separate and apart from having cameras in the courtroom. That there has to be a compelling need for the closure and that there are no less restrictive means. So it's up to the state and the defense, I guess, since they both want the hearing closed, to come up to articulate a compelling need for the closure. There's nothing in the stipulated motion that articulates a compelling need to close this proceeding, and there's certainly no suggestion of any less restrictive means. So the motion on its face is really defective, and if a court were to close this proceeding entirely without a hearing, that would be automatically subject to appellate review, that the media coalition, I'm sure, would go to the appellate level in Idaho and seek what would be a writ of mandamus to ensure that the court be open during these proceedings.
The issue of having cameras in the courtroom for the trial is a separate issue. Media outlets, including Law and Crime, have argued to keep cameras in the courtroom during the trial. Griner has argued on behalf of many media outlets many times to keep cameras in the courtroom.
Public ought to know about what's happening at a mass murder, a trial of an alleged mass murderer, and the more the public knows, the better for everybody involved.
Attorney for Kohberger and Taylor has brought attention to 3 unidentified male DNA samples from the crime scene. She contends that these samples have not been shared with the defense team. However, prosecutor Bill Thompson counters this claim. Thompson articulated, quote, "What I'm hearing sounds like conjecture. They're hoping for more evidence, but we can't provide what we don't have," unquote. Thompson further clarified that the 3 disputed samples were not included in the combined DNA index system, also known as CODIS, because they were deemed ineligible. He asserts that Taylor was notified about this by the lab. Consequently, they have requested for a protective order to be issued. The 3 DNA samples may have been ineligible for CODIS due to matching with staff DNA. According to protocol, any unidentified forensic profiles obtained during case analysis must first be compared against the staff index before entering into the database. If a match with a staff member is found, the sample is deemed ineligible for CODIS and should be removed. As such, the procedure ensures the integrity of the database, preventing potential contamination or false positives from staff interaction. It's highly likely that if investigators were involved in the crime, their DNA at the scene could lead to unexpected matches in the results. If these individuals are also part of the investigative team, there's a high chance of bias in not considering themselves as suspects. Defense is likely to argue that the investigation wasn't thorough due to this potential bias, and they might use these unexpected DNA results as strong evidence to support their argument. Bill's comments stating the DNA results were ineligible for entry into evidence could indeed add a significant twist to the case. If the evidence is deemed unqualified, it may raise questions about the investigation's integrity and objectivity. The defense might argue that this is a clear indication of bias, particularly if they weren't notified about these results as per the Brady rule, which requires the prosecution to turn over all exculpatory evidence. Moreover, the defense's insistence on the pain interrogation of Kohberger suggests they believe it holds crucial information that could potentially affect the outcome of the case. The existence of a sealed Brady notice in this case is certainly significant. This indicates that the prosecution has identified and disclosed information that could be exculpatory or impeaching, potentially impacting the defense's case. Although the specific details of this notice are sealed and not available to the public, the fact that such a notice is present could be crucial. This undisclosed information could potentially sway the defense's arguments, especially if there are other signs of bias or procedural misconduct. The presence of the Brady notice could also cast a shadow on the prosecution's credibility.
Someone alleging that their client is being railroaded by police, which is exactly precisely in the professional sense what Ann professionally has alleged. But in the street terms, right, he's being railroaded, he's a patsy for police. Now, that behind closed doors, closed hearings, doesn't make sense to me. Her coming to open court and stating that she believes she could openly waive Speedy rights without informing her client that they were going to sign away Speedy rights and what that meant. And then we see him in the same hearing after she says, I haven't prepared my client for this. And then we see that very constitutional right signed away in that same hearing. And I don't see it passing with the federal level of appellate courts that are going to come into play here, especially when it pertains to a death penalty case. And if it does, then it might be any other innocent person who winds up in a death penalty chair or execution method, insert firing squad, insert death chamber here, because states are finding new and innovative ways. The state of Alabama has introduced nitrous oxide death. Roll Tide, Idaho has introduced the firing squad, insert whatever sports reference for Idaho. And American citizens do not agree that they are appropriately handed out according to the sentence holding no prejudice, meaning it's handed out equally among all races or among equally atrocious crimes. It seems to be handed out willy-nilly. And as you can see, as far as death penalty in Idaho is concerned, well, they're trying to add their 9th death litigant to the charts here, and it ain't looking good. But I don't see death penalty able to go through here, okay? But as it sits, and I'm not really seeing this go the way that people who believe in innocent until the state meets its burden, because we understand that the state has to meet that burden, because we have to let, if it means we have to let a guilty person go, we prefer a world where no innocent person sits for their lives in prison, much less goes to their death for a crime that they didn't commit. And if that means that they have to let vicious killers go here or there because they couldn't prosecute the crime in the way and order that they are supposed to constitutionally, well, then that's what it means, folks, and that's the price we have to pay, because there will be a price. But I don't think that's the case here. I think this is the case of the patsy who didn't have the privilege of private representation, who had the most corrupt county's public defender hired at a quadruple rate to represent him, who disturbingly has seemed to have contradiction after contradiction. And although the contradicting case here that would conflict with her interest of being a defense attorney on the case was less than was originally represented, she has never personally met Xana Kernodle's mother, who has been represented by the public defenders in Kootenai County. However, there are other public defenders. Granted, I do believe that a defendant within a certain degree should be allowed to waive certain conflicts because they believe that someone can set that aside. The fact that you have a bias for something doesn't mean you're not able to set the bias aside. Personally, I like to pretend that my child is in the position of my adversary, and how would I give that the benefit of the doubt if that were the case, and I can kind of flip how I'm thinking about it, and lots of people are able to do that. Doesn't mean that because someone has a bias or because someone has a conflict that they can't represent someone. And of course we're able to understand why on the defense's side, we want to be able to waive versus not on the prosecutorial side. Of course, we'll waive a conflict for someone saying, hey, I think I can set this bias aside and get you out versus, hey, I think I can set this bias aside and choose your death. At the same time, though, I think it's probably pretty easy to hire someone, especially at the rate she is getting, which is, Ann Taylor is getting more to represent him in this case than many private attorneys are getting. Had her client not waived his speedy trial rights, would she be going back to Kootenai County's public defense wages? Yes, she would. She'd be going back to an average of $50 an hour versus $200. We're talking about the difference between making $2,000 a week and making $8,000 a week, okay? And that's a large difference. Now, can she drag this out and get her defendant to waive his rights? Hell yes, she can, because he has nobody else, and that's like his hero to him. And he probably truly believes in her. And she's the only person that he's seen since his arrest in person that has believed his side, believed his innocence. Even if he wasn't innocent, she was ready to defend that, right? And that is a bond and has with their defense attorneys, and they oftentimes trust defense attorneys that they shouldn't trust. And look, there are cases, plenty of cases, where a defense attorney has to add more people to a case that in order to defend that client and maintain their constitutional rights, they need more assistance. They need more investigators. They need more paralegals. They need more help. And it should typically be very easy to get that. You know why? Because it's very easy on appeal to present things like that. Oh, well, look at this district judge who prejudiced my client by not allowing the proper funds in order for his defense team to properly defend him and uphold his constitutional rights. And that is something that a court has the burden of giving a defendant, any defendant, much less one who they want to take the life thereof. So what am I saying? I'm saying that Ann Taylor should have went and asked for more help. I didn't want to see a defense attorney who hasn't added more than the typical amount that would make the opposing side not look completely tipped in the prosecution's favor. That is to say that there have been two attorneys added, one who is another Idaho alum and another who isn't very impressive resume-wise, but honestly, I can say he has kicked ass in several motions. I've been quite proud of some of Jay Lodgen's work. He is the proud writer of that line. If it is to take notice of this case, it should be at the blatant way that the state of Idaho denies the constitutional rights of its citizens. Yeah, so I was very impressed with his work. But to be honest, that could be the work of his paralegal, especially if he's in private practice on his own. They hire the best and oftentimes hand down a fraction of the payment to their star team that they have doing most of the grunt work, okay? So who knows what the hell is really going on here. I hope that she does come through for him. But what I'm saying, if she wanted to drag it out, well, I'd say that we just watched her do it by saying she didn't prep him, by allowing the judge to intimidate her into even putting that shit on the table. Nope, if she didn't prep him, she should have held at that. No need to sign over Speedy if she hadn't prepped her client to sign it over with his signature on that day. And let me also tell you something else, American citizens, you have the right to object, even if you have an attorney right there. You do not have to remain silent, and you can object to anything your attorney doesn't object to, and it will uphold your own right at court. It will uphold your appellate rights. So what I'm wondering is why in this case we haven't yet seen her go above judge's head, saying that all of these conflicts not coming into play here. And I also don't understand why originally they didn't just assign the district court's public defender, which is listed on the Latah County website. It's not Kathy Maybew, so it shouldn't be a conflicting attorney in the first place to have just represented him with that original magistrate judge before the district judge, John Judge, was actually assigned to the case. And just so everyone knows, oftentimes in America, magistrate judges are hired officials through a vote, okay? So they are voted electoral officials. They're hired through an electoral vote to be the judge, and they don't have to have law degrees. They can literally not have a law degree, but be the judge of law. Now, the good thing is, if you are the proud new owner of a felony case, you'll have a district judge. And in most states, the district judge has to have a law degree, a Juris Doctorate degree. Sometimes it really doesn't make a fuck. I watched a judge give my dad an illegal sentence, to which his attorney objected. Judge, that's illegal. And the judge said, yeah, I know. I went to law school too. By the time he gets done appealing it, he'll have done more time than I wanted him to do anyway. Prosecuting attorney is turning in paperwork to explain the visit of an FBI agent. What the hell is a prosecutor who turns in his official answer to the court? I do not want to cross-examine any of your witnesses. Through an order to cross-examine an expert witness, that is the venue, the appropriate venue for challenging the qualifications and the credibility of a testifying expert, not through intimidation tactics conducted outside of the courtroom and at an expert's door in the middle of the night. That is what a thug does. That's what Bill Thompson did. And in a cosmic fucking joke, we literally have a case here where the prosecuting attorney is turning in paperwork to explain the visit of an FBI agent.
Is Mr. Kohberger willing today to write? Really anticipating this, but just in case, and hypothetically, I grabbed a Odyssey. We have so many things going on. There's a lot of issues left to resolve, and as you know, understand that, and you're all thinking this, that it's going to be very difficult to put everything together that needs to be put together. This is a very significant, complicated case. I don't know if you take a look at that form.
Will you have just a moment?
Yeah, go ahead. Thank you. So, Mr. Kohberger, did you read this over?
Yes.
Okay. What I'm talking about is the written waiver of speedy trial.
Yes, you understand that? Yes, we already talked about it. Yes.
And you agree with the waiver of speedy trial? The waiver.
Do you accept the based on our discussion, you're a waiver of these rights.
What's the deal in Moscow? Why has this become such a big deal?